How's it going, everybody? I'm back. I've been getting a lot of messages as to what was in the background when I was talking with my friend from New Jersey. Um, so this is why I'm making that video. I want to first off thank Father. Without him, I wouldn't have the intelligence that I do, even though most of you might not agree. I also want to thank him for putting certain people in my life that have been helping me and guiding me as well through him. And I also want to thank those that have been donating, that understand that this does take time and it takes money and energy in many different ways, from making copies or just simply going to the law library, through doing legal research, or uh, when I pay people to see their emotions. I really don't know what I'm getting until I've already paid for it. Sometimes I gotta filter through a lot of crap and find one or two good things and add it to my emotion to make it stronger. But yeah, I want to thank those people because they've been helping me move forward, and so thank you guys. Okay, I'm gonna start, and it says attorney and client. His first duty is to the courts and the public, not to the client. And wherever the duties to his client conflict with those he owes as an officer of the court in the administration of justice, the former must yield to the latter. Now, let me tell you what I think this means. I could be wrong, and if you think I'm wrong, go ahead and leave a beautiful message like most of you morons do. Okay, it says here, his first duty is to the courts and the public. Okay, that's who the attorney's duty, basically that's where his duty lies. Not to the client. Let's get that right there in first sentence, not to the client. And wherever the duties to his client conflict with those he owes as an officer of the court in the administration of justice, the former must yield to the latter. Which means, if there's a conflict of interest of like the attorney helping his client out because the court wants to take the client's money, which is usually the case, then he must yield to the court and let them either take a lot of money or some money. The point is they take money regardless. And it's kind of like the salesman when they start off high. You got to put so much down. Well, can you put around $5,000 down? Well, we only have 2,000. Great. There you go. How about 3,000? Can you do that? Well, we'll see. Can you borrow money? Yeah, we can. It's kind of like that. They kind of highball you, so that when the attorney says, well, hey, look, instead of paying the $500 you got, the judge wants, how about if I knock it down to 200? Can you do that? Yeah, man, thanks a lot. Appreciate it. Ooh, thanks for not using a condom. I love that. So, that's what I gathered from reading this. The office of attorney is indispensable to the administration of justice and is intimate and peculiar in its relation to and vital to the well-being of the court. An attorney has a duty to aid the court, which means help, in seeing that actions and proceedings in which he is engaged as counsel are conducted in a dignified and orderly manner, free from passion and personal animosities, and that all causes brought to an issue are tried and decided on their merits only, to aid the court. Again, of course, they can't say to aid the court and help the court and screw you enough times for people to understand that basically they're screwing you. Not all attorneys, just 99.9% of them, probably. I don't know. Who knows? There are some good attorneys out there, but then again, I'm reading this and I'm thinking different. Now this is where it gets interesting. Okay, let's look at what a client is. A client is one who applies to a lawyer or counselor for advice and direction in a question of law, or commits his cause to his management in prosecuting a claim or defending against a suit in a court of justice. One who retains the attorney is responsible to him for his fees and to whom the attorney is responsible for the management of the suit. One who communicates facts to an attorney expecting professional advice. Clients are also called wards of the court in regard to their relationship with their attorneys. This is like double speak right here, and I'll explain how. Because it says clients are also called wards of the court in regard to their relationship with their attorneys. It's saying that, but it's not saying, well, what does that mean when you're in court? How does that change your relationship between you and the court itself? Okay? Now, this is how. Let's see what a ward of the court is. Infants and persons of unsound mind, placed by the court under the care of a guardian. It also states their rights must be guarded jealously. And then in the end it says, see guardianship. So there you have it. If you want to get an attorney, at least now you'll be informed as to what you are being considered. You're an infant and a person, well, an infant and or person of unsound mind, placed by the court under the care of a guardian, which would be the attorney. Okay, so I remember I had this judge one time says, "Whoa, Mr. Pimentel, you know what they say about having yourself as a client?" And I said, "Well, yes, sir, I do." And for those that don't know what that means, it's saying if you have yourself as a client, or if you have yourself for a client, you're considered a fool. You know, basically you're stupid, because most people don't know how to defend themselves. That's why they say that, but it's really propaganda. And my response to him was, "Well, yes, sir, I do know what they say." He said, "Then, well, I going to tell you that I'm going to hold you to the same standards as an attorney." I said, "Fine, sir. I understand that, but I also want to state for the record that I'd rather be considered a fool than a person of unsound mind." He just gave me a look like he wanted to kill me. You know, it was funny, at least for me, because I had that on the record. But so, you know, it's true. You'd rather be considered stupid than crazy. And another thing is, for those of you that have heard or have been involved in getting when they want to do that psychological evaluation, I'm gonna see if I can eventually make another video to show and prove that they use a psychological evaluation as an arraignment tool, basically to arraign you. Because remember that anything you sign is a contract. Just keep that in mind, folks. So if a judge is giving you an order to go somewhere to do a psych eval, then they shouldn't be asking you for your signature when you get down to the psych eval, because it's an order. You see, just ask logical questions and you'll shatter their world. They'll go crazy because you're not falling for their stuff. So once again, for those of you that like this information, please go ahead and donate, because from what I see on YouTube, I'm one of the few that's even putting this information out there, because once you start putting this information out there, all eyes on you. So a lot of people don't want to put themselves in danger, but they want to go ahead and I guess benefit from others doing it. So thank you guys if you guys do donate, and if you don't, well then hopefully you still learn and help others out. Thanks a lot.